Good morning, everyone. Mr. Harris, I think the floor is yours.
Good morning, my lords. Good morning, Mr. Hoskins. I propose to begin my submissions by reverting on some of the questions that were put to me yesterday, beginning with that from Lord Sales. The intention, subject to your lordship's other direction, is that I will conclude my submissions by 11:30 on ground 1 and then hand over to Mr. Mitriou to deal with ground 2.
Thank you.
So Lord Sales put to me yesterday and asked me to consider overnight, by reference to rules 2 and 4 of the CAP rules, in particular what could be characterised as the fairness and justice point. In other words, isn't it relevant to suitability and hence certification to ascertain whether there can indeed be a trial that will be fair and just? So I address that point first. And I begin by saying again to the court that the certification is concerned with questions of form and not with merits. And can I just briefly take you to make good that point to page MS 1341, which is a passage from the Microsoft case. I believe in your copy bundle at MS 1341, it starts halfway through paragraph 99 of the judgment of the Supreme Court.
Yes.
And I'm reading from several lines down at the end of that paragraph. It's the final 2 sentences. She noted, that Chief Justice in the Hollick case, to which we referred yesterday, she noted, however, that the certification stage is decidedly not meant to be a test of the merits of the action. Rather, this stage is concerned with form and whether the action can properly proceed as a class action. And then if you were to turn down to the next page, 1342, and at the bottom, this is in paragraph 102 of the same judgment, and the Supreme Court in this case, Microsoft, makes a very similar point. It reads, I think, the final sentence on that page: the certification stage does not involve an assessment of the merits of the claim and is not intended to be a pronouncement on the viability or strength of the claim. Rather, it focuses on the form of the action in order to determine whether the action can appropriately go forward as a class proceeding. So my first point then is that the certification stage is emphatically limited to questions of form and not the merits. It's not intended to be an inquiry predictive of the outcome at the trial or the success on the merits. And the next point is that if the tribunal had or has any doubts about whether there are any data available to establish pass on for either all sectors or for any particular sector of the economy, that is a factor that's completely neutral as between bundling or separate claims. Take, for instance, a very rich person who might, as an individual claimant, want to come along and establish the loss to him or her by reference to his or her spending in all of these sectors for the 16-year period. Well, that individual will also need, at the certification stage, evidence of the availability of the data as across the sectors, if that's the right test. Of course, you know that my submission is that you only need to show some evidence of the availability of data of pass on to the level, the indirect purchaser level, full stop. But the point I make is that this question of the availability of data across all the sectors would be the same in an individual claim as compared to a multiplicity of bundled claims or a collective claim. So it therefore doesn't distinguish as between the two. It's not a question about whether it's suitable to proceed as a collective as opposed to as an individual, which is the question of form that we're concerned with at this stage. In reality, the inquiry into the amount or value of the data in all of the sectors, which is what the tribunal was concerned with in this case, was a complaint and an analysis of the substantive merits of the claims across these sectors. In other words, it was analysing and seeking to predict the success or otherwise of the claim in any given sector or across many sectors at trial. But we've just seen that that's precisely not what the Supreme Court in Canada says certification is about, on the test that it was all agreed that we should apply in this case. The focus of certification is on form merits is very clearly made out in our own domestic legislation, and that's what I like to turn you to now. The best place to pick this, Lord Leggatt.
Isn't part of the form of the action, if you're proposing an action brought claiming a group loss, to see whether there is some prospect of establishing loss at that group level? And for that purpose, it must be reasonable, isn't it, to see whether there's any prospect of getting enough data to enable you to calculate the loss at that group level, particularly pertinent when what you're claiming to do is to treat as a group all the people in the country, or who spent 3 months in the country over 16 during a 16-year period. So if you're really going to calculate a loss at that level, you've got to have some idea about how you're going to go about it, and that's what the test is all about, isn't it?
Well, the issue there is the stringency of the test. How much does one have to have at this stage across all of these different sectors? But the first response is that that's clearly not what was going on in Microsoft, and I'll come back to that. But
it may not be, but they weren't asking the same question, and we're asking about we're concerned with aggregate damages in this claim.
Yes, I take that point, Lord Leggatt, but one has to ask oneself the question of what is reasonable and just at this stage to seek to have presented to the tribunal by the class representative. And there are a number of relevant points, many of which I made yesterday, but I can identify again today as to why it's not fair or just to expect the proposed representative to come with all of that data across all of the sectors more than... Of
course it isn't. Of course it isn't. But you're redefining the question. The question is whether there's any hope of getting enough data across enough sectors to make possible the kind of enormous computation on a global level that you're aiming for.
Well, I'll take that point in a minute in a different way, which is to show you what evidence of the availability of data that we did in fact have at this CPO hearing. I will show you that.
We're not retrying that hearing, though.
I know, but you're asking me whether I should have had some evidence of the availability of data across more than the two sectors that have been identified by Mr. Hoskins. And the answer to that question is I did have that, and I will show you that. So I don't accept that this case, it's been eloquently advanced by Mr. Hoskins as if I only had evidence of the availability of data in petrol and supermarkets, but that's not right. So that's one point to bear in mind. And the second point to bear in mind is that by reference to the supplementary expert report that I can also take you to in brief, it is common ground that there is, and there would have been at this CPO hearing available for presentation to the tribunal, more evidence of the availability of more data across more sectors. And I'll give you a little bit of the detail of that in due course. But what is abundantly clear is that everyone proceeded on the basis that we were applying the test in Microsoft at paragraph 118. And that doesn't require evidence of the availability of data across all of the sectors for all of the years. So in other words, we went into the hearing applying that test. It's still common ground that we should be applying that test. And it's been said after the event, well, hang on a minute, you should have had more data, more evidence of the availability of data, even though it doesn't say that anywhere in the legislation or indeed even in the guide. And so in due course, I shall, if I can put it like this, to some extent, put your minds at rest that this is not a juggernaut claim, which is hopeless as regards the prospect of adducing some evidence of the availability of data across more sectors. So I shall show you both the original experts report and in brief, the supplementary expert report. But can I just identify for you again in list form what the reasons are why, or at least some of the reasons why, it's not fair or just. This is Lord Sale's point by reference to rules 2 and 4. For the proposed class representative at this stage to be producing a much more extensive list of the availability of data, even for a claim like this. And they are as follows. That number one, it's not required in Canada and they have the same legislative objectives. Number two, the focus here is upon the form as a collective, not upon the substance, in just the same way that it is in Canada. And the critical question of form as regards aggregate damages, in my respectful submission, you heard this from me yesterday, is whether or not they can be dealt with as a common issue. Because if they can, it makes good procedural sense for them to be heard together in a collective, because it avoids duplication of fact-finding and law, and it saves a waste of judicial resource. So far, same legislative objectives. Number two, is a focus on procedure and form, not substance. Number three, it's not reasonable, in my respectful submission, to expect the expert to have conducted an exhaustive survey of all the potential sources of availability of data across all these sectors before seeing what the defendant is going to produce in disclosure. And that's a point that is specifically made by the BC Court of Appeal in Hewitt at paragraph 107. So that's my third point. It's actually not reasonable to expect an expert to go off and do this exhaustive survey before seeing what the other side is going to produce. So it's a touch, not onerous test. It demands a minimum evidentiary standard. Number four, this is more generally pre-disclosure. So it's not just that I don't have what is available in the data banks of Mastercard, what I described yesterday by reference to their expert report as the overwhelming factual evidence. It's not just, but I also don't have relevant disclosure from other third parties. And what you will have seen from our expert report is that there is a wealth of potentially relevant data to which we drew attention in our original experts reports as being available, which is the test. And that is the data in the myriad merchant and retail actions that are already in progress as between those merchants and either Mastercard or Visa. Visa obviously being relevant because it's essentially the same substantive question of pass on from the from merchants into the consumer level of the chain. So there is an asymmetry of information generally, not just as regards Mastercard, but as regards the fact that I don't have, as a proposed class representative, access to these other private, non-public sources of information that are relevant. But nevertheless, we identified them in our expert report and identified them as available. And I don't accept Mr. Hoskins' point that there is somehow a bar or on me getting a disclosure order in these proceedings, if certified, from Mastercard of the materials that it has received from those third parties in those actions. It's in the possession and control of Mastercard, and or will be. And there'll be an argument, maybe, about whether or not I can get the order as against Mastercard. But it's certainly available, which is the test. And of course, I note the very great irony of Mastercard saying on the one hand that, oh, you haven't identified the availability of data. Of course, I Mastercard, I'm going to have, or do have, some of that data, but I resist showing it to you. But be that as it may. The next point on the list, so that's number 5 now, is that, as that is also pointed out by the BC Court of Appeal in Hewitt, there is the question of the economic viability at the CPO stage of a funded claim seeking mass consumer loss, of saying to that expert, as well as all the myriad other things that the proposed class representative has to spend money on to get to the certification hearing, you've actually also got to go and do a very detailed job on the availability of data. That, as you will have seen, the proof is in the pudding in our case. That required, in our case, another expert report, a supplementary expert report, parts of which you'll see in due course, plainly cost an amount of further money. And what the Court of Appeal says in Hewitt, another reason why it's not reasonable or just for you to expect there to be this exhaustive across the entire sector recitation of the availability of data because of the economic viability of the action. And then the sixth point is this, that if that is the test, this stringent test, more stringent test than that which is set out in 118 of Microsoft, even though everyone has agreed that's what we should be applying, if it is in fact stronger than that, then it has the potential to knock out the very sorts of mass consumer claims that I tried to present, and therefore put us back in the position that we would have been in prior to the BIS paper that says, why is reform needed? Precisely because reform was needed, because mass consumer claims of this type were not getting off the ground, that these changes were made. And that's why it was wrong of the tribunal at the end of its judgment to say, oh, well, essentially, and I paraphrase, and I hope I do fair justice to, in this paraphrase to what it says at the end of that judgment, but, oh, well, too bad. Not, mass consumer claims like yours won't succeed, but so be it. In fact, it's a reason that should be prayed in my favour. And what you will see, and I won't get time to show you this later, is in the Hewitt case, again, it says specifically that the unconscionability, which is its word, of not allowing these claims to go ahead, a claim of this type to go ahead, should be weighs in favour. That's, if you want the reference, it's Hewitt 124, para 124, which is at MS 1237. They say is the unconscionability of not allowing this type of thing to go ahead weighs in favour of certification. But what I can remind you of and give you the references to is that the Court of Appeal essentially agreed with that point, and we say quite rightly. So at paragraph 28 of the Court of Appeal judgment, MS 215, you don't need to turn this, and at paragraph 59 of the Court of Appeal judgment at MS 225, it refers to the near impossibility of being able to calculate on an individual loss at this remove in time, talking about my case, and that's right. And then the phrase at 59 is it's a practical impossibility to proceed other than a collective action on the facts of my case. So I say that all of those, that recitation, that list, if you like, of just and reasonable factors stands in my favour and militates in favour of a relatively not onerous test, which is what the Court of Appeal, the court has said repeatedly in Canada. So I said, though, to make out this point well, form versus substance, I would take you to Rule 79 in particular. Can I please invite you to turn up Rule 79, which you'll find at MS 112. And what one has at 1182 is the text of Rule 79. And we've seen it before, so I'll take this quickly. You have 79.1a, b, and c, and they are all matters of form. Is it identifiable class? What, in other words, what's the form of the identity of your class definition? Does it raise common issues as opposed to non-common issues? In other words, is it going to help you on duplication and saving of resource? That's a question of form. It's nothing to do with substance. And likewise, are they suitable to be brought in collective proceedings? And then the latter, as you know, is spelled out in more detail in 79.2. If we just trace our hand or our eye down those, we'll see that each one of them is connected with form and not substance, not merits. A, is it an appropriate means? Well, plainly form. The costs and benefits of continuing the collective proceedings. Again, a matter of form. Are there any separate proceedings? Again, a question of form. The site, well, I won't say the same word every time. D is the same. E is the same. F is also the same. You've heard that submission from me yesterday. The key question there, and I'm going to return to this in due course, on suitability is whether they are common and hence can avoid duplication and save judicial resource. Though I am now as well addressing Lord Sale's point of, he said to me yesterday, well, isn't it also a question of fairness and justice? And that's what I'm addressing now. And then G, alternative dispute resolution. In other words, is there some other form that's more suitable or preferable? So 79, 1 and 2, they're all about form. And that stands, my lords, in sharp contrast to what then happens in Rule 79. So in 79.3, there's a distinct question of whether or not any given collective proceeding should be opt-in or opt-out. And what does the legislator there say in this statutory instrument? What is said is that the tribunal may take into account all matters it thinks fit, including the following additional to those set out in paragraph 2. And what is additional to subparagraph 2? Well, the first one is A, the strength of the claims. That's a clear recognition that 1 and 2 have got nothing to do with assessing the strength of the claims or the merits. But on this question of opt-in, opt-out, you do in fact have regard to an additional matter, strength of the claims. And I'm going to come to 4 in a minute, but can I just develop this point about strength of the claims in number 3 by reference to the guide? So if you could just go back up a few pages to 1169 in the bundle, please. Paragraph 6.39 of the guide. The tribunal guide elucidates a little upon this additional requirement of strength of the claims. And could I just invite you to read to yourselves, please, members of the court, the content of that first bullet point. So, my lords, what one sees that even on this additional matter at the certification stage, it's a very high-level view. It says that, form a high-level view. The strength has to be immediately perceptible. This is the light touch, even on the merits on this additional point. And what's more, it then ends by saying that in a case like mine, you've almost certainly passed this hurdle because my case is a follow-on claim. I already have an infringement in decision against Mastercard upon which I rely. So going back then to MS 1182, this is back in the text of Rule 79, what we then see is that this distinction between form on the one hand and merits on the other is equally well drawn out at subparagraph 4. So at the hearing for the CPO, collective proceedings order, the tribunal may hear any application by the defendant. And what are those applications? They are merits applications. They are either strikeout or summary judgment. So that's the process and the procedure by which one focuses upon merits, strikeout or summary judgment. But Mastercard hasn't done that. So I don't have to concern myself with it. They could have done that, but they didn't. And this is not just a technical point. On the contrary, this is a fundamentally the structure of this legislation. So form, that's what I was addressing at my CPO hearing, not merits. I wasn't facing one of these other applications. And it's important to note that an application to strike out, or for that matter for summary judgment, calls for evidence directed at the merits, not evidence on this procedural question of form. But that wasn't what I was gearing up to face and faced at the CPO hearing. There wasn't a challenge to my merits. And yet, the tribunal, wrongly, because it failed in my respectful submission to respect this division in the legislation and the reasons for it, did engage in an analysis, essentially, of the merits of the data that was available to me in respect to various sectors for use and application at trial. And a good place to pick this up, my lords, if I may put it like this, is in our written case, if you were to turn, please, to MS 177, that's the respondent's case, and in particular to paragraph 55, what you'll see is that we identify two specific instances of where the tribunal has wrongly engaged in a probative value assessment of the evidence of availability of data that we did present. So to take 55A, the tribunal criticised our reliance upon the pleadings and evidence in the claims brought by other retailers against Mastercard in a range of sectors. But the Court of Appeal was correct to find, in pointing out that the limitations on the usefulness and probative value of material, the tribunal was asking itself the wrong question. We plainly had evidence of the availability of that data, but they didn't think that it was very good data. The court says that's wrong. At the Court of Appeal, at the certification stage, the question for the CAT was not what they were capable of proving, had this been the trial of the action. And then even more obviously, if I may respectfully put it, was the criticisms levelled by the CAT, upon which Mr. Hoskins expressly relies, of the RBB reports. So this is my paragraph 55B, and was picked up in a comment from Lord Legat yesterday. The tribunal went to that RBB report and found that the data in it was incomplete and difficult to interpret. Well, plainly, that's an assessment of the probative value of that data in its potential application on the merits at trial. But on any view, that's not what we're doing here. On any view at all, that was available data. Irrespective of what one thinks about its probative value. And indeed, as Lord Legat also pointed out yesterday, the tribunal itself found in that same paragraph, and we quote at the bottom of our page MS 177, we have no doubt that some sectors have been the subject of detailed study. Well, on a true understanding of the Microsoft test, that gets me home. But in a moment, I'm going to show you that the expert report that was put in and how it has data, availability of data across more sectors than just petrol and supermarkets. And in fact, why don't I do that now?
Just before you do, Mr. Harris, does your submission then really resolve to this, that so long as you can point to the existence of data, it's not necessary for you to conduct, or indeed appropriate for the tribunal to conduct, any evaluation of its cogency?
Well, my lord, the answer to that is it is a very light touch on the cogency of the evidence, where you already have a credible and plausible methodology that is not purely theoretical or hypothetical, which is my case. That was expressly accepted by the tribunal in, it's either para 77 or 79, where they use the phrase methodologically sound. In those circumstances, yes, I accept that it's part of the some basis in fact test that there has to be some evidence of availability. But the answer to your specific question is no. You do not get involved in a probative value assessment of the cogency of that evidence, let alone across all parts of the claim for all years, because that is too high a test. And as we saw yesterday by reference to Hollett, that's not a generous approach. I'm quoting there from Hollett, and not consistent with a purposive approach to certification so as to give effect to the purposes of the legislation.
Well, does that mean then that if the tribunal considers that the data which has been proffered as available is without any substance or merit at all, it simply ignores that circumstance?
Well, it's I accept that there has to be some evidence of the availability of data to apply in your methodology. But my answer is that it is, as I said yesterday, to be contrasted with no evidence of the availability of data, And where you've got a credible or plausible methodology, as we have, then it goes barely beyond that in those circumstances, because what one then has to do at this stage is have regard to the opinion of the expert, which is that he or she thinks that that is the data that's capable of being used in his or her methodology. And that's what we have in this case. We have, as you'll see in a moment, Dr. Velenovsky said expressly, we'll see this in just a minute, that it's simply not credible to think that across the economy in this long period there won't have been pass on. And deference does have to be given, as the Court of Appeal, deference does have to be given, in my respectful submission, as the Court of Appeal said expressly, that the CAT didn't give sufficient deference to that opinion. But in addition to that, my lord, I just simply do not want anyone leaving my submissions thinking that somehow we didn't have, on the facts of my case, evidence of the availability of data. It's just not right.
You've alerted us to that, all right.
I'm grateful. I'm sorry if the tone of my voice.
No, don't worry. Yes.
And so in answer, another way of answering that is the Hollick some basis in fact test, which is the one applied by the Court of Appeal in process, is there some basis in fact, which is some evidence, as opposed to, is it just hopeless and there's no basis? We're not in that territory. And so perhaps I can just show you then, what I'm going to do now is show you a couple passages of the report that we did have, and then I'm going to show you a few short extracts from the supplementary expert report. So can I please...
I'm sorry, Mr. Hoskins was having some problem, I think.
I simply say, before Mr. Harris goes to the supplemental report, he has to apply for it to be admitted in evidence. He has an application to that effect. He hasn't asked for that application to be heard, and I object to that application. It's simply not possible for Mr. Harris to refer to that expert report at this stage of his submissions, not having moved his application to admit it in evidence.
What do you say to that, Mr. Harris?
I don't accept that. The court has had regard to it de bene esse, and I propose to make submissions to what you've had regard to de bene esse. And if at the end, having heard the submissions, the court regards it as necessary for me to move an application, I'll simply do so by reference to the written materials. I don't need to take up time to do that now.
Well, let's hear what Mr. Hoskins says to the proposal that we hear it de bene esse.
Well, I strongly object to that for two reasons. First of all, the legality of the tribunal's decision must be judged on the basis of the evidence before the tribunal, and that must be uncontroversial. If Mr. Harris does want to rely on supplemental expert evidence, he has to make the application first. It's simply not right for him to read out and rely upon passages of a report that was not before the tribunal, that the Court of Appeal ruled should not be admitted, and that this court has not even been asked to rule on whether it should be admitted or not. I see what Mr. Harris is trying to do. He wants to get his retaliation in without having to go through the proper form. It's simply not an appropriate way to proceed.
Well, you say it's not an appropriate way to proceed. We frequently do admit, or at least not admit, but refer to evidence, de bene esse. That's not an exceptional course at all. But do you say that it shouldn't be followed in this instance?
I do, my lord, for the reason that the legality of the tribunal's judgment must be addressed on the basis of the evidence that was before the tribunal, not something that was produced afterwards.
Right. Well, now, Mr. Harris, do you want to move your application now?
No, my lord, I don't wish to move the application now. I wish to proceed in the same way that it was proceeded in the Court of Appeal, which was to make brief reference to it de bene esse, and then decide at the end whether or not it needs to be formally admitted. And in fact, my principal submission is we'll end up in the same place as the Court of Appeal. They didn't rule it out. What they said is it's not necessary to formally admit it at this stage. And so,
Lord Leggett,
time now.
Lord Leggett.
I wonder if it would be possible if you could explain to us before you do that what the relevance of it will be to the issues that we have to decide to see what wasn't before the tribunal.
Yeah, I accept that the key question is whether I had adduced on behalf of Mr. Merricks, some evidence of the availability of data, albeit on the very light touch, given that I had a credible and plausible methodology in the expert report that I am about to show you. But I apprehend that there may be some nervousness on the part of the court as to whether or not it might have been possible to adduce more such evidence had only anybody known that the test was in fact more stringent than the paragraph 118 Microsoft test. Nobody knew that, and I'm going to show you why I'm right on the true understanding of that test, and it's just some evidence of availability of data to the indirect purchaser stage. But so as to put the minds of the court at rest briefly, that if anyone had known at that stage that it was more stringent than that, then we could have met it. It's as simple as that. It just involves showing a few passages that show that the experts would have been able to adduce plenty more evidence on the availability of data.
Well, I think we're going to have to adjourn into private session in order to rule on this application. The court has decided that we will receive a reference to this material de bene esse, but that does not indicate that we have reached any view as to whether it is to be admitted in the case, and we will decide that at a later stage. Now, Mr. Harris.
I'm grateful to Lord Kerr. Just before turning then to both the original expert report and to the supplemental with brief references, I'd just like to respond a little further, if I may, to Lord Leggett's question to me. And just identify that the magic, if you like, of the aggregate award in this case, well, let me take a step back. It's important to just remind ourselves how this aggregate award is put together. It's 3 steps. The first one is ascertain the relevant volume of commerce across the economy. That is, if you like, the aggregation of all the respective volumes of commerce for all of the 46.2 million people. And that's absolutely capable of being done, and nobody disputes it. That data comes from Mastercard. And then what you have to do is establish the overcharge. That's step 2. And again, nobody disputes that that's capable of being done both credibly and plausibly, and by reference to data that is available. And then the question is about pass on. But the question of pass on is exactly the same analysis that would have to be conducted by an individual. And so it doesn't distinguish between an individual and a collective claim. So go back to my very wealthy individual that I mentioned earlier on, somebody who has, say, 10 million that he or she is willing to spend on pursuing his or her own claim for expenditure during the 16-year period across all sectors. Then that individual would also have to identify pass on across all of those sectors. And yet there's no suggestion, in my respectful submission, that an individual would be locked out at the early stage, at an interlocutory stage, on the basis that the individual hadn't been able to identify evidence of availability of data across all of those sectors. And if it were the case that such an individual were to be denied at that interlocutory stage, how would it be done? Would be done by reference to the summary judgment or strikeout of that individual's claim. That's how it would be. It would be a merits test of what had been presented by that person versus that individual versus what hadn't been presented. And yet the proof here again is in the pudding. Mastercard could have done that, but it didn't. It could have come and said, on the merits, your claim is hopeless, you won't succeed at trial, but it didn't. It's very telling that it didn't. It must not have thought that it had that ability or those prospects. In any event, it didn't do it. But what's gone wrong with the tribunal, with respect, is that notwithstanding that it should not have been looking at the merits and wasn't facing a strikeout or a summary judgment application, it has nevertheless strayed into an assessment of the probative value of that data at this preliminary stage. So I hope, Lord Leggett, that answers the point about, you asked me about the form of a collective aggregate award, and that's my answer to that point. And can I just then take you I'm conscious of time passing, so take you, I think, briefly to the original experts report, section 6, and then even more briefly to the supplementary report. So the original experts report begins at MS 512, and the passage to which I'd like to draw your attention in particular is on 542, under the heading section 6, the MSc pass-on. And what one has here is, without any doubt, in my respectful submission, at 6.2.3, an identification of available sources of data to be applied by this expert in furtherance of his opinion, that is 6.1.1, that there is no credible basis for the assertion that MSc was not passed on. So at A, market studies, competition authority decisions and other research as described in section 6.3. Now, I don't have the time to go through each of those, but if you were in due course to turn to section 6.3, you'll see that there's an identification of multiple studies, decisions and other research. So that is without any doubt some evidence of the availability of that data. But the one I will just switch to focus on in a little bit more detail is B, evidence and analysis filed by the different businesses that are bringing similar claims, damages claims against Mastercard. That is, again, just written in those words, is evidence of the availability of data. And it's important to note, in my copy over the page at 543, that Dr. Velenovsky in this section of the report says this covers, this means the evidence and analysis filed by the different businesses, approximately 70% of all payments processed with a card in the United Kingdom. So what he's identifying as being available data to be applied in his methodology is all manner of sectors covering 70% of all payment cards processed by reference to the sectors in Appendix 3 that Mr. Hoskins took you to. But if you go back to 6.2.b, then he identifies the sectors. He says, based on the evidence from those claims, just pausing there, it's unarguable that that is some evidence of the availability of data. He says it, based on the evidence from those claims. And he goes on, it may be possible to estimate the pass on in key sectors, such as food and drink, clothing, household goods, motoring, entertainment, travel, and other retailers. That's not simply petrol and supermarkets. Mr. Hoskins, on behalf of Mastercard, would have it. That's not that at all. The 70% to which he refers is all of those sectors: food and drink, clothing, household goods, motoring, entertainment, travel, and other retailers. If you wanted to turn up Appendix 3, you could see a more detailed breakdown of the relative percentages getting you that you get from each of those sectors. I don't need to do that, because all I need to do is show that he's identified some evidence of the availability of data. And let's not forget that in those cases, there will be a dispute, and in some of them there already is a dispute about pass-on, precisely because Mastercard is defending itself in those cases inter alia on the basis that all of the loss was passed on from those retailers. Oh, and to whom was it passed on? To my clients. So that is a very strong basis, in my respectful submission, to say that we have both a plausible and credible methodology that can be populated by data that is available. And what one does not do on any view of paragraph 118 is then subject that data that's listed here as identified as available to a probative value assessment. And then can I also just draw your attention to the fact that the VAT point cannot be simply set aside in the manner that Mr. Hoskins sought to do. If you turn to MS 546, please. I mean, obviously, I'm not going to read everything on the intervening pages, but it's all relevant, available data that supports the methodology and makes it have some basis in fact. But I just don't have time to read through it all. But I do specifically draw your attention to 6.3.8 on MS 546. This, you will recall, is the reference to the increase in VAT And this is specifically one of the matters that Mastercard's own expert expressly relies upon as demonstrating pass on to none other than my proposed clients. But importantly, what is VAT? VAT is a sales tax that applies across the economy. It doesn't just apply to supermarkets, doesn't just apply to petrol, it applies to all vatable goods and services. And yet Dr. Velenovsky, as agreed with by Dr. Niels, the expert for Mastercard, and the evidence I showed you yesterday, is saying that this is available data that will show pass on of a similar cost. It says, for example, studies show that 2.5% increase in VAT, a cost increase not dissimilar to the credit card MSC, was fully passed in January 2011, was fully passed on by United Kingdom businesses. Mr. Hoskins then falls into the very same error as the tribunal when he turns over the page and he says, oh, but it only says that it will be passed on, or it would be. That's an assessment of the probative value of these particular studies, not is it a credible and plausible theory, incidentally agreed with by his own client through his expert evidence, that there was pass on across the sectors of the economy? And is there some available data to work that methodology? Yes, because he's pointing to these reports. I accept that at trial, it might be possible for somebody acting on behalf of Mastercard to say, oh, well, that was only a prospective will, or it might be would. That's the stuff of trial, not the stuff for now. And so I'm going to put that, in the interest of time, aside and just take you briefly now, as promised, to the supplemental report. And what you will see is that begins, for me, in a separate bundle. It begins on page MS 1003. And then the passage that I wish to draw you to in the first instance is at 1010. And what that says is Dr. Velenovsky, picking it up in the middle of para 2.2.5, he says in terms that the standard actually expected by the CAT as regards the evidence of availability of data came as a surprise. We had not been instructed to set out in detail all the evidence of the availability of data. That's because, as we will see in my next set of submissions, that's not what it demands in Microsoft, which is the test that everyone said that they were applying. But perhaps more importantly for now, you will see that in 1014, at para 3.3.2, second sentence, first sentence, I do not accept that there is insufficient data available. And this, of course, is a CPR 35 expert report with the statement of truth and bona fide opinion. And then he goes on, I'm confident that there is readily accessible data for the whole UK economy. It can be examined using well-established and undemanding empirical techniques to estimate individual sectoral and product cost pass-on rates from merchants to the class of consumers Mr. Merricks is seeking to represent. And then, although plainly there's not time now to go through this report in detail, if one just flicked through it, I will identify the much more detailed list of evidence of available data for other sectors. So at 1020, there's yet more data for supermarkets, and then you turned over 4 pages, you will see the detail, including the identification of all manner of reports that one just scrolls down. And then at 1024, there's yet further elucidation of the data available in petrol and all manner of reports identified. And then there is the heading travel on page 1025. And again, there is, I'm just showing you in slightly more detail, 1026. This is the evidence which, by the way, Dr. Velenovsky said in terms in the oral evidence in the CPO hearing that had been studied, and I quote him here, to the nth degree. The travel sector and airlines had been studied to the nth degree. So he already adverted to these possibilities in his oral evidence at the CPO hearing. And here he gives some of the detail. A, research by Usman. B, PricewaterhouseCoopers study. C, Duplantis, etc., etc. Then there's the heading data availability in the next page as regards airline, rail, road by route and type of sale ticket. All manner of potential data can be sourced from the following. I just read 3.4.33. And then one goes on. There's another specific sector identified at 1028 as regards drinks. Under the heading at 1028 data availability, he identifies a whole list of available data for use in his methodology. All kinds of reports. This can be used to measure elasticities and pass on directly. Over the page 1029, 3.4.40, there is a vast amount of information analysing beer prices, studying prices behaviour, etc. And then one goes on. And then what he does is the next section of the report, section 4. So I'm now on page 1034. Is he identifies at paragraph 4.2.4, having listed out all now of the pending claims against Mastercard and Visa, identifying the merchants, the sector and the subsector. Gentlemen, my lords, I beg your pardon, all of that detail is to be found in Appendix 1A and 1B. I plainly don't have time to go to it, but it can all be found. And what he says then at 4.2.4 is I estimate that 57% of the subsectors have been pursued in one or more of the merchant actions against Mastercard or Visa. Wow. And what's more, that is, in the next bullet point, representing 87% of the total card expenditure in this later period. So here is lists of availability of data for use in his methodology, covering the preponderance, the large preponderance of the relevant VOC, including well over half of even the subsectors. And that is available for use in the methodology. Now, at trial, it could be argued, oh, well, the time period is too late, so the probative value is less. At trial, it could be argued, oh, well, you can't extrapolate backwards. At trial, it could be said, oh, yes, but what about this particular sector? You haven't got anything on that. But that's answered by Lord Sale's point put in argument yesterday, that where you have these other sectors, it's the point about the rent rebates. You can cross-refer an inference and draw appropriate conclusions. That is the stuff of trial. So that's why I wished to draw your attention to the supplementary expert report. And then just for completeness, although this passage is cited in our skeleton argument, Dr. Velenovsky simply did not accept the criticism of the probative value of the RRB report, which was never put to him in the hearing by anybody. If it had been, he would have responded as per section 5. And this is important for the question of form versus substance that I now come back to. Had this been a strikeout or a summary judgment application, including by reference to the RBB report, then Mastercard in that type of procedure would have had to say in advance of the hearing, aha, look at your RRB report, it's not worth the paper it's written on, its probative value is limited because of this, that and the other. And then what would have happened? We would have responded. We would have responded in the terms of section 5. But the tribunal didn't do that. Instead, there's a one-sided after the event criticism of the RRB report, wrongly mixed up with questions of form. That's where it trespassed into merits and substance, which in my respectful submission, it shouldn't have done, given the clear division in the legislative framework. And so those are submissions regarding both the aggregate damages and the fairness and justice of proceeding the manner for which I suggest. I just want to add one more point, in particular in response to Lord Sale's invitation to me overnight by reference to rules 2 and 4. So rule 4 of the CAT rules talks about ensuring that the parties are on an equal footing. And of course, at the CPO stage, we are very much not on an equal footing for the reason that I gave before, which is the asymmetry of information as between my client and Mastercard, and because my client simply doesn't have access to, at this stage, the other non-public sources of information, specifically from the retailers and merchants, to show pass on from them to my clients. And so it's not on an equal footing for me to be told, my class representative, to be told, well, come along now and show me in fairly exhaustive form, and indeed, if the tribunal were right, by reference to probative value as well, all the sources of evidence upon which you're going to rely. That's just not fair. That's not an equal footing. And if I may respectfully put it, which makes this point rather well in its written intervention. What it identifies is that you not only don't across the board have access to this generally, these carteller arrangements are very broadly secret and they're concealed. And even if they're not, it doesn't mean that you have access to the information. If I can then move on, I'm very conscious of the time. In terms of the dissonance that Lord Sales mentioned yesterday, these are also my answers. Even if there is a dissonance as regards, say, one particular sector or another, that still doesn't mean, for the reasons I've given, that you shouldn't be entitled to at least try at your trial to prove those points of your case. And I also rely upon the fact that you need to have, my lord, in my submission, a practicable test to apply, both for my case and for all these other cases. And when you questioned Mr. Hoskins yesterday repeatedly as to what is the ... or what is the rubric, I think was one of the expressions used to put into this test, with respect to him, and one understands why, he didn't have an answer. He kept saying, well, I don't want to give a hard-edged test, and just look at the words of the legislation, of the rules, and it's all in the discretion of the tribunal. Well, with respect, that is not a helpful way to proceed at a CPO hearing. All the cases that you've been told about that are backed up behind this case, awaiting the answer of what the CPO test about, it's no good to say to them, oh, well, it's all at large in the discretion of the tribunal. But it is of use for them practically to be told. The test means exactly what it says in paragraph 118 of process, namely that there has to be some evidence, not no evidence, and it has to show some pass on to the level of the indirect purchasers. That is an easy, practicable test to apply. And what's more, one of the reasons that we look at Canada is because it's a test that has worked and is working in Canada. In a moment, after I've just dealt with a passage in the Court of Appeal judgment on common issues, I'm going to make some brief submissions on why the 4 reasons why we rely on Canada. So that's just a little bit of a roadmap. But before I do that, I just want to come back to common issues. Mr. Hoskins was not right to say today that common issues, as opposed to suitability, hasn't been an issue in this case. Or with respect to him, is simply not right. If you turn at paragraph 35 of the Court of Appeal judgment at MS 218, you'll see that the Court of Appeal identifies that Mr. Merricks had 3 grounds of appeal from the tribunal to the Court of Appeal. And the third one is 7 lines down, paragraph 35. And partly for the same reasons, that the CAT adopted the wrong legal approach to its assessment of the degree to which the individual claims raise common issues. We did challenge how the tribunal had dealt with or failed properly to deal with common issues, and we did succeed in the Court of Appeal. And it's Mr. Hoskins and his client who have chosen not to appeal that issue. And let me just show you how the Court of Appeal dealt with it in a non-challenged manner. And it's paragraphs 45 to 47 of the Court of Appeal judgment. And that's at MS 222. The Court of Appeal was right in my respectful submission. And as I say, this is not appealed. It was right anyway to say at 45, a critical issue in deciding whether the proposed methodology is a suitable and effective means of calculating loss to the class is to determine whether it's necessary to prove at trial that each member of the proposed class has in fact suffered some loss due to the alleged infringement. Although the expert evidence must obviously provide a means of calculating the level of pass-on of the MIFs from merchants to consumers via price, there's some controversy as to whether that is sufficient to make the global loss suffered by consumers a common issue, absent being able to show that each member of the class was in some way adversely affected in their own purchases. Just pause there. Now that question has been very definitively answered in Mr. Merrick's favour in both Godfrey and Microsoft, but then that is adopted by this Court of Appeal. The CAT, as I have said, avoided that controversy in this case by accepting that not all of the issues need to be common issues. But, as indicated above, there is no requirement under section 47C2 to approach the assessment of aggregate award through the medium of a calculation of individual loss. The appellants experts have not attempted to do so. In that, they have the support of the Canadian authorities, which in cases like Microsoft have approved a top-down method of calculation on the basis that the level of pass on to the class as a whole will be a common issue for all individual claimants. It seems to us that the same approach should be adopted in relation to section 47B. Lord Leggett, sorry.
You're refighting again the battle you won in the Court of Appeal, but does the result have any impact on the further issue that was then decided? And if so, what is it?
Yes, the impact is that where you've got an aggregate claim for damages for aggregate loss that is common across the class, then it means that that is the sort of claim that is eminently suitable to be brought in collective proceedings as opposed to individual proceedings. Because
is it the same? Surely it's a different requirement to first decide whether there are common issues and then decide whether, amongst other things, or an aggregate award of damages. They're totally different. Or are you saying there are really two ways of saying the same thing?
What I'm saying is that on the question of form, one has to, it is highly relevant to the question of form and procedure, whether you can ascertain your loss collectively as opposed to individually. If you can, so that you therefore don't have to have 46.2 million individual trials and you don't have to use judicial resort making the same legal analysis and factual inquiries 46.2 million times, then that is highly relevant to the question of suitability. Highly relevant. That's why it is the focus in Microsoft. And so I don't accept that there is some complete divorce on this question of aggregate award between, on the one hand, suitability and on the other hand, commonality. Lord Briggs.
Well, I was just going to observe that it comes back into the suitability analysis under Rule 79(2)A, doesn't it?
It does, my lord.
Yes. Thank you.
Yes. And this is why it's important that the CAT got this wrong with respect. It's been corrected, and as you say, I've won that battle. It's not appealed. But it means that, having not appreciated, with great respect to the CAT, with very great respect to the CAT, because it didn't appreciate that this was a point substantially in my favour, the commonality of the loss, therefore its suitability, it therefore gave greater scrutiny and thought that I would have had to have had more on the other individual aspects of 79(2). But in fact, I didn't. This is very much in my favour, not against me.
Right. Well, you've a fairly limited amount of time left, Mr. Harris.
Yes. Yes. What I'm therefore going to do is simply identify for you the relevant, more of the relevant passages in Microsoft, and finish off by reference to the key paragraphs of the Court of Appeal judgment on ground one. And so can I then just invite you respectfully to turn up the Microsoft case begins at page MS 1294. And can I ask you please just to note, because I won't have the time to go through them, that the Court of Appeal began its analysis, and in my respectful opinion, correctly, by having regard to more than just paragraph 118, It started by reciting paragraph 102 and 103. That's to be found in paragraph 41 of the judgment of the Court of Appeal at MS 220. And I rely upon 99 to 101 as well. And I would respectfully invite you to reread those. I've already cited part of 99 today and part of 102 about it being a question of form, not merits. And then that is picked up again in 102 and 103. And may I just draw your attention in particular to a sentence in 105 of the judgment, which you will find at MS 1343. And this wasn't cited by the Court of Appeal, but it was one of the ones in between what they cite. And it's the second sentence of 105. Consequently, the outcome of a certification application will not be predictive of the success of the action at the trial of the common issues. I think it is important to emphasize that the Canadian approach does not allow for an extensive assessment of the complexities and the challenges. But of course, as you know, that is exactly our criticism, and indeed the Court of Appeal's criticism of what the tribunal did. You don't need to turn it up because I want to show you more passages on MS 1343, but at paragraph 77 of the CAT judgment, with which you're familiar, it's precisely what the CAT did. It said, but making every allowance for the need to estimate, extrapolate, and adopt reasonable assumptions, i.e. what would happen at trial, sorry, they were my words, I carry on quoting, to apply that method across virtually the entire UK retail over a period of 16 years is a hugely complex exercise requiring access to a wide range of data. Missed the next sentence, and then it reads, given the massive size of the claim, a difference of even 10% in the average pass-through rate makes a very substantial difference in financial terms. Well, it couldn't be clearer, but that is an assessment of the probative value going to might end up achieving at trial, even to the point of saying, well, it's not acceptable to have a 10% difference in the value. That is exactly what the Supreme Court in Canada said you're not supposed to do. And then I'm just going to pick out, I rely in addition on 106 through to 113 of the Supreme Court's judgment in Microsoft. And just picking up a fact in Microsoft at 109, this you'll find this in your bundles at MS 1345. It's just worth noting that in Microsoft, not only was it an indirect purchaser claim, but that, as it says here, this was the plaintiffs, so the proposed represented class were alleging that they were injured by multiple separate instances of wrongdoing, and that these acts occurred over a period of 24 years and had to do with 19 different products. But there is nowhere in this judgment at all that says, well, when it comes to that part of paragraph 118 that talks about some evidence of the availability of data, that would have to be shown by reference to each of the 24 years or each of the 19 products. It doesn't say that. That's not how it's been applied. On the contrary, what it says is that you only have to have some evidence of the availability of data showing pass on to the indirect purchaser level. And so I simply invite you to reread, as the Court of Appeal cited, 114 through to 119, and that puts in context the key paragraph that was cited by the CAT at 118. And at the risk of slight repetition, for which I apologise, this is not a test in 118 that needs to be split out and dissected as if there were separate requirements. This is the Holic test of basis in fact, and it's not disputed, have a credible or plausible methodology that is not purely theoretical or hypothetical, and that it does credibly and plausibly show pass on to that indirect level of the chain. And as you've seen in the expert report, there certainly was some evidence of the availability of data to which that methodology is to be applied when it's understood that it has to show, and I quote here from the bottom of 115, which is in your bundle at MS 1347. So it's the last sentence of 115 of Microsoft. In indirect purchaser actions, this means that the methodology must be able to establish that the overcharges have been passed on to the indirect purchaser level in the chain. And then I'm not going to do this at all, but I do strongly urge you to have further regards to the Ewart case, which is to be found at MS 1212, and you'll see that many of the most helpful citations in that case are set out in our written case, but that case specifically addresses, very specifically addresses, how much data do you need in order to apply your proposed methodology. And I just cite for your notes from MS 1215, paragraph 9 of that judgment of the Court of Appeal in BC, on the very question of how much data needs to be provided. It reads, in my view, the jurisprudence of this court and the Supreme Court of Canada establishes that the plaintiff must provide some evidence that the loss component of liability can be proven on a class-wide basis, but it is not necessary to identify the specific data that will be required in order for the proposed methodology to do so. And it goes on, in my respectful opinion, this is at the top of MS 1216, it was an error in principle to require the plaintiff to prove at the certification stage the existence of all the facts the expert would need to utilise in implementing his proposed methodology. So my respectful submission, that strongly endorses the interpretation that we give to the test that everyone has said that should be applied. And then that leaves me only to finish off in the few minutes available by taking you back to the Court of Appeal judgment and after the passages we've already looked at, so after 45 to 47, so you'd find this on MS 223. And just picking it up then at 49, the Court of Appeal, in my respectful submission, was perfectly correct to say that the CAT refused to certify because it was, and it quotes from the CAT, unpersuaded on the material before us that there is sufficient data available for this methodology to be applied on a sufficiently sound basis. That is the antithesis of what is said in those paragraphs from Microsoft. It's talking about applying, that means apply at trial, and it's talking about the amount of data across the entire set of sectors as opposed to what should have been some evidence of the availability to the level of indirect purchases. And then 50, I respectfully, that's correct from the Court of Appeal. I don't have time to read it out. I'll skip over to 51. The Court of Appeal was totally correct in light of the submissions that I've made about purpose, the relevance of Canada, and what it actually says in Microsoft, to say that the appellants experts in their report and in their evidence at the hearing acknowledged that the evidence gathering process was still at an early stage, but sought to identify the likely sources of the relevant material. Although the CAT was entitled to satisfy itself that the expert's proposed methodology was credible, it was not appropriate at the certification stage to require the proposed representative and his experts to specify in detail what data would be available for each of the relevant sectors in respect of the infringement period, i.e. the whole period. The experts had identified expected sources of the data and other materials such as pleadings in the Sainsbury's litigation, and as you know, many more than just Sainsbury's. It was 70% by volume at that time, it's now 87% by volume of commerce. The CAT pointed out the limitations on the usefulness and probative value of this material for the purpose of the present proceedings, including that in many actions by retailers against Mastercard, the issue of power will not be explored, or at least will not be determined. But the preliminary nature of those proceedings is not a bar to their being relevant as a possible source of evidence. The certification stage, the question for the CAT was not what they were capable of proving had this been the trial. And therefore, the CAT asked itself the wrong question. And that was the misdirection in law that the Court of Appeal has corrected. As to the specific points that Mr. Hoskins has mentioned about mini trial and the nature of the questioning and the ability to have an ongoing assessment of the certification requirements or subclasses and what have you, I rely upon the answers in our written case upon those. None of them is a good point for the reasons we've given in writing, but most fundamentally, they don't get round this central point that the Court of Appeal rightly identifies in section 51, where on ground 1, the CAT misdirected itself in law and applied too stringent a test. And so, my lords, unless I can be of further assistance, those are the submissions on behalf of Mr. Merricks on ground 1, and perhaps we have Mr. Mitri on ground 2, with your permission.
We'll have a short break and then we'll look forward to hearing from Mr. Mitri.
Very grateful. Thank you.
Thank you. Right. All ready? Mr. Mitri.
May it please your lordships, I'm going to address you, as you know, on ground 2, distribution. And what I propose to do is first to explain our case in a nutshell by reference to the legislation, and then secondly turn to respond to Mastercard's particular arguments.
Sorry, just a moment, please.
We haven't gone back to being live, sorry.
Sorry.
I have to say that again.
Well, I've made a very careful note of it. I'll make sure that you're sorry,
as is normal.
10 seconds from now.
Thank you.
Now, Mr. Mitri.
May it please your lordships, I propose in relation to ground 2, first to explain in a nutshell our case, in particular by reference to the legislative provisions, and secondly then to turn to respond to Mastercard's particular submissions. The starting point, of course, is section 47C2 of the Act, and you've seen that now a number of times, so I won't go back to it at this stage, but it gives the tribunal, as you know, power to make an award of damages in collective proceedings without undertaking an assessment of the amount of damages recoverable in respect of the claim of each represented person. And it's an important provision because in many collective actions, it will be possible when analysing the evidence in the round to reach a robust estimate of the loss suffered by the class in aggregate, but it may be impracticable to calculate the extent to which an overcharge caused loss to each individual member of the class. And it may be impracticable either because the evidence is simply not easily available, or because it's much too costly to do that for any particular individual, given what they might seek to gain in terms of damages from the proceedings. And the present proceedings, of course, are a very good example of the difficulty that the Court of Appeal highlighted, and which section 47C2 confronts, because we know that there is a finding of liability here. We know that there's a finding that Mastercard infringed the competition rules, and there's good reason to suppose that the infringement caused harm to consumers, but there are very obvious and significant obstacles to consumers bringing individual claims. Indeed, the proof's in the pudding, because we haven't had any individual claims, but in particular, the duration of the infringement and its nature mean that in order to establish his or her loss, an individual consumer would need to adduce evidence of their spending over a 16-year period from all merchants from which they made purchases which accept Mastercard. And the court will readily see the difficulties with that. So quite aside from the difficulties in obtaining evidence, of course, the burden of proof would lie on the consumer. It's highly unlikely that any individual award would justify the costs of that kind of exercise. But we also know that in this case, there's a top-down method which is capable of establishing the loss caused to the class as a whole. And we've been through that, and so the court understands how it works. But an essential point is that the VOC is calculated not from an individual's own records, but from Mastercard's own records. And that can only really be done if one takes a class-wide and aggregate approach. So we say it's precisely this type of case to which Section 47C2 is directed. And the difficulty is that if once an aggregate award of damages has been made, Mr. Merricks were then nevertheless required to distribute the aggregate award according to how much each individual member of the class has lost, then all of the benefits of Section 47C2 would be forfeited. And that's the essential point that the Court of Appeal made in its judgment below. And in our respectful submission, it's correct. And could I just take the court back at this stage to remind you of how the Court of Appeal put it at paragraph 60 and 61 of its judgment. And you'll find the passages at MS 225 to 226. It's at the very end of the Court of Appeal's judgment. And you'll see that what the Court of Appeal said at paragraph 60 on MS 225 is it first of all highlighted the intention behind the aggregate damages award, and then said at the end of paragraph 60, the making of an aggregate award does not, as already mentioned, require the court to calculate individual loss, or importantly, to assess the damages included in that award on an individual basis. Why then should it be distributed in that way? And then over the page 226, once it's accepted that aggregate damages can be awarded and therefore assessed by reference to the loss suffered by the represented class as a whole, it becomes difficult to justify a reversion to an individual calculation of loss for the purposes of distribution. Claimants in this class will know that they stand to be compensated, if at all, on a per capita basis, and can choose, if they wish, not to be included in the action. But once the assessment of the aggregate award is complete, then on one view, Mastercard has no locus to be heard on the question of distribution and no right to object. And then at the end, the vindication of the rights of individual claimants is achieved by the aggregate award itself. And we say that that's correct and that it accords with how the statutory scheme addresses the distribution of an award. Now, the court has already seen, because Mr. Hoskins took you to it, that there is nothing in section 47B of the Act which requires aggregate damages to be distributed on a compensatory basis, or indeed any basis at all. So there's no guidance in section 47B. And if we turn back to section 47C of the Act, which is at MS 1154, that, of course, is the provision which includes the power to seek an aggregate award of damages. You've seen section 47C2. Then subsection 3, looking at the rest of that section, applies to opt-out proceedings and provides that the tribunal must make an order providing for the damages to be paid on behalf of the represented persons, either to the class representative or to some other person. Then you see subsection 4 provides an analogous power rather than duty, where you have opt-in proceedings. Subsections 5 to 7 address what happens if any part of any damages award is not claimed by the represented persons within a specified period. Subsections 8 and 9 are similarly not relevant to the point at issue. And so what one has is a position where the primary legislation permits damages to be awarded on an aggregate basis, in other words, without assessing the amount of damages recoverable for each individual claim, but then doesn't contain anything which requires that aggregate award to be distributed in a way which is compensatory to the individual. Indeed, it doesn't contain anything which directs how the award is to be distributed at all to members of the class once the aggregate award has been made. Now, we referred in our written case at paragraph 16 to the government consultation paper that preceded the adoption of these provisions. And it's worth, I think, turning it up. It's at MS 2634. And the court will see at paragraph 5.27, one of the difficulties that the legislation sought to address. So in cases where the amount of damages per claimant is very low, only an opt-out action is likely to succeed in delivering redress. Because the action is the basis of an estimation of the total size of the group, the damages can be calculated accordingly. So that's the position we're in our case. That's why we're seeking an aggregate award. And a fund created to deliver redress to claimants. This can then be used in case-specific ways to deliver redress, such as in the example of Deco v Portugal Telecom, in which 120 million euros was delivered to consumers as described in box 5. And then what you have in box 5 is an example of a claim filed by the Portuguese consumer organisation alleging an overcharge by the Portuguese telecom company. And you see that following this, PT reached a settlement with Deco, whereby it granted all of its consumers free telephone calls on Sunday for a period of approximately 3 months. And so what one has is an example of a collective action where an aggregate award was no doubt sought, calculated on the basis of everyone's loss, that the effect of the overcharge in general. But then the way that benefit then accrued to the consumers that had suffered the loss was in a broad brush way, which didn't seek to be compensatory. And that's how we say the Act is intended to work. Now, my lords, turning in the legislation back to the tribunal rules, and Rule 75, which I don't think you've seen yet. This is at MS 1178. And what you see in Rule 75.1 is that an application has to be made by way of a collective proceedings claim form. And then over the page on 1179 at paragraph 3, there's a list of what the collective proceedings claim form shall contain. And if you see at I, little I, that includes the relief sought in the proceedings, including, where applicable, an estimate of the amount claimed in damages, including whether an aggregate award of damages is sought. But there is no requirement in the claim form for the class representative to say anything whatsoever about distribution. And if we move on to Rule 78 on page 1181, MS 1181, this is the rule that's concerned with authorisation of the class representative. And you'll see at subparagraph 3, in determining whether the proposed class representative would act fairly and adequately in the interests of the class members, the tribunal will count all the circumstances, including, and then at C, whether the proposed class representative has prepared a plan for the collective proceedings that satisfactorily includes, and then there are three items listed. But again, what's not included there is a plan for distribution. Now, the court on the next page, MS 1182, has already seen now a number of times Rule 79, and so I'll just make the point shortly that none of the factors in Rule 79.2 address the question of distribution. And so although 79F, as you've seen, includes the consideration whether the claims are suitable for an aggregate award of damages, no particular provision is made here in relation to distribution. Similarly, Rule 80, the collective proceedings order, which starts at the bottom of that page, that contains a list of things that the order made by the tribunal has to contain. And again, none of them relate to distribution. So what we have, in short, are a number of rules concerned with the certification stage, none of which lay down any requirement as to distribution. There's no requirement to plead anything in relation to distribution, and none of the mandatory factors that the tribunal has to take into account relate to distribution. Now, as Mr. Hoskins said, distribution is addressed in rules 92 and 93 of the tribunal rules, and you'll find those starting on MS 1186. And rule 92 is the relevant one for present purposes. The court will see that where the tribunal makes an aggregate award of damages, it's required to give directions for assessment of the amounts that may be claimed by individual represented persons. And those directions include a method or formula by which such amounts are to be quantified. So that's a broad way of putting it. And we say that the use of the words method or formula certainly mean that this is not restricted. Distribution is not supposed to be restricted to a distribution which is done in a way which is individually compensatory. It's put in a much broader way. And then we see, and this is important, at sub-paragraph 3, that the class representative shall give notice to represented persons in such manner as the tribunal directs of any hearing to determine what direction should be given in accordance with paragraph 1. And any represented person may apply to the tribunal to make either in writing or orally at that hearing. And so one has, what one has in the rule is the position whereby the class representative must make a proposal to the tribunal once the aggregate award of damages has been made. But then any represented person, any member of the class that disagrees with that proposal and has something to say, can apply to the tribunal to be heard. And it may well be that if a member of the class puts forward some other method or formula which the tribunal deems to be preferable, that that's the one that's selected. And where I'm going with this point is that given that this is an important procedural right that's conferred on members of the class, one can readily see that where the tribunal takes the view, as it did in this case, that it's going to determine whether the provisional proposal put forward by the class representative at the very earliest stage of the proceedings is appropriate or fair, it shouldn't be doing that without having heard members of the class who wish to be heard. That's how the rules are set up. Now, the guide to proceedings, in view of the time, I'm not going to go back to it because I think you've seen from the guide to proceedings, paragraph 6.82 to 6.83, which are at MS 1172 for your notes. Mr. Hoskins took you there. And the key points that derive from the guide is the substantive point, first of all, that the tribunal will be concerned to ensure that the method proposed is fair to the interests of all class members. And so that's put in a very broad way, not compensatory, fair. And the second point is the note that typically, as a matter of procedure, the defendant will not be involved in the process. And it's easy, my lords, to understand why that is, because if an aggregate award of damages has been made, then what that does is it assesses what loss has been caused by the defendants in a global manner. And so as far as the defendant's concerned, it's not having to pay anything that it shouldn't pay, because this is loss that it's caused to this group of people, to this class of people. And at that point, its interest disappears, because its interest is making sure that it doesn't overcompensate the class. Once that's been determined in trial, then it no longer really has any interest in determining how the award is to be distributed. So, my lords, that's how we say it hangs together. And with that, I want to turn to Mastercard's specific argument. And we say, first of all, that in light of the statutory scheme, it's not surprising that Mastercard's primary position is to accept that the legislation does not lay down that distribution be effected in a compensatory manner, in a manner that's compensatory to the individual. It accepts that in terms of paragraph 116 of its written case, and Mr. Hoskins proceeded on that basis orally, although he has an alternative argument to which I will return. This was a concession, or Lord Leggett.
Sorry, just while I'm thinking of it, Mr. Beecher, before you move on, would it be reasonable to say that the compensation comes in this way, that in many cases, the fairest way of distributing the amount will be to give more to somebody who can show they've suffered a larger loss. But in some cases, where there isn't the evidence or it's too costly to determine that, it may simply be that the fairest way is to divide it up equally or in some other manner.
My lord, we completely agree with that, and so it's no part of our case to say that the notion, the concept of individual compensation is in any way irrelevant. Of course, it's a relevant consideration. It may be highly relevant in any particular case. And in answer to my lord's question, one can readily see that if one has a much more straightforward type of situation, so you've probably seen in the authorities that there was another application for a CPO that wasn't accepted by the tribunal relating to mobility scooters. So if one has a single product like that, and people are able to come forward, you may have somebody that can come forward and say, well, I bought 4 mobility scooters for various reasons. And it's easy on the evidence because people can readily demonstrate how many mobility scooters they've bought. Then one can see that the starting point would be very different. But my lords, this case is a paradigm of a case in which that kind of exercise would be nigh on impossible to carry out and would defeat the very idea behind having an aggregate award of damages. And so we say, and it will, my lord, also depend on the size of the award. And that is a very good reason why all of this process of determining distribution is done at the end when one knows what the size of the award is. Because one can see in the present case that if this case is permitted to proceed, and if it's very successful and the award is extremely large, then it may be justifiable to tweak the proposal, to change it, and to have something which does take greater account of spending of each individual. But my lord, if it's a more modest award, or in any case where the award is more modest and the sums that would be expended and also the burdens that would be placed on individuals to demonstrate their loss would be great, then fairness might well require that's not compensatory at all, which is just a per capita division of the damages award. And so we say that's a very important point, and it's a critical point in understanding how, in really giving effect to section 47C2. Now, my lords, I was going to say that the concession that Mastercard made on the meaning of the legislation, in other words, on the fact that the legislation doesn't require distribution to be accorded in a compensatory way, was one that was made in the Court of Appeal, but it wasn't Mastercard's position in the tribunal. And I make that point not for any forensic reason, but because it's relevant when one comes to look at the tribunal judgment and discern what it was the tribunal was doing. So did the tribunal make an error of principle, as we say, or did it simply treat the compensatory principle as being one amongst many potentially relevant considerations, which is what Mr. Hoskins needs to establish. And so I'm going to take the court back to the tribunal judgment in a moment. But first of all, I'd ask you to look at Mastercard's arguments before the tribunal. And we see this at MS 788. This is part of the transcript, and what you see at the end, this is a passage in Mr. Hoskins' submissions, and then you see if you go to line 23, so he's explained the proposal we put forward. Now that's the proposal the applicant has put his money on, and then he says, but that proposal clearly fails the test because it doesn't reflect individual loss. And so you say, to be fair, you gave them both the opportunity to say, well, I think this might be right. And they both said, well, no, we can't speculate any further. So the proposal you have does not, we say, come anywhere near close to being compensatory. Now, I fully appreciate that the way that the Act is set up is that you don't have to have a neat fit with compensation, but you do have to have a reasonable relationship with it. And this proposal does not have that reasonable relationship. So, my lords, what's being said there in terms is a comment about how the Act is set up. So it's a point that's being made about statutory construction. And the argument was that the Act requires that at the distribution stage, you need a reasonable relationship with the compensatory principle. And we say that it's that stance that Mastercard took that explains why, that casts light on the tribunal's judgment and explains why it went wrong. Now, while we're on submissions below, Mr. Hoskins took the court to our submissions, to Mr. Merricks' submissions, and at MS 422. And if we could just please turn that up. So these were in the written submissions, and you'll recall that Mr. Hoskins took the court to paragraph 13, and at the point where these submissions say the tribunal and Mastercard may rest assured that we all sing with one voice on the issue, distribution should be as compensatory as possible. But I want to explain the context in which that arose, which is evident from the surrounding passages. So first of all, what's said is should be as compensatory as possible, taking into account countervailing factors, such as the claims process being straightforward and proportionate. But also, if you turn back a page to MS 421, you see, actually, perhaps if the court could start on MS 420 at little d, you see there the precise way in which it's put. So, as to distribution, of course, ideally, class members would each be compensated according to their exact loss. However, the raison d'etre of the aggregate damages regime is precisely that such individual calculation might be inappropriate or indeed impossible, with the archetypal example being none other than a mass consumer claim with modest per capita recovery, such as the current proposed proceedings. With this point firmly in mind, and so then I'm not going to read it all out in view of the time, but I just wanted to explain to the tribunal the context in which those words that Mr. Hoskins seized on arose. And really it comes back to my answer to my Lord Legate's point, which is that we're not disavowing that the compensatory principle might not be relevant, we're not saying it's irrelevant at the distribution stage, and in any particular case it may be highly relevant, but we say that it's not a statutory requirement, and there will equally be cases, which we say this case is likely to be one, where it's not the fair response, it's not a fair response or a proportionate response to distribute in accordance with that principle. Now, turning to the tribunal judgment, we say that it's very clear from the judgment that the tribunal approached the question of distribution on the basis that it was necessary for distribution to result, at least broadly, in compensation to each individual, and it therefore misdirected itself. And if we could pick up the judgment at MS 265, and paragraph 79, and just looking at the first sentence for a moment, if the total loss could be calculated in the aggregate manner discussed above, it's nonetheless necessary to consider how that would translate into determination of the level of individual loss. And so we say that, pausing there, what the tribunal is saying is that that's a necessary thing. It's necessary to translate the aggregate award into individual loss. It's not saying, well, that might be desirable and that's a relevant consideration. It's saying that it's necessary. And they then go on to say it's particularly important because the proposed methodology doesn't really go to determination of a common issue, but in a sense circumvents the problem of an issue which is not common. Now it made an error, as the Court of Appeal found, in saying that it's not a common issue, but generally, standing back, it seems to treat the tribunal, the award of aggregate damages, as some kind of aberration which requires the tribunal then to circle back and rectify at the distribution stage. And we say that that's not right at all. And then moving on, paragraphs 80 to 83, which I'm not going to go through in detail, proceed on the basis that individual loss does indeed need to be established, and discusses the degree of precision that's required. And so you have the reference to the broad axe approach. But then paragraph 84 at MS 267 is important, because what's said there is the problem that the tribunal identifies. The problem in the present case is that there is no plausible way of reaching even a very rough and ready approximation of the loss suffered by each individual claimant from the aggregate loss calculated according to the applicant's proposed method. The broad axe which the applicant seeks to deploy is not being used as a means to estimate actual compensatory loss at all. And so again, it's proceeding on the basis that what's required is, at least at a broad level, the estimation of individual loss. And we say that that's not correct. Then on page 268, moving on to paragraph 86 of the tribunal judgment, there is some exploration in this paragraph by the economist member of the tribunal as to whether some other method could be used which would result in distribution that's a little bit more compensatory than the proposal that we advanced. And the interesting part of this paragraph for my purposes is the last two sentences. So since no analysis or even argument was presented on that basis, it's impossible for us to assess whether even this basic test would be satisfied by the proposed distribution. And then importantly, that is aside from the question whether this test would be appropriate for determination of compensatory damages as a matter of law. So again, that's a very clear indication that the tribunal is revealing as to the tribunal's approach, because we say that it shows that it was proceeding on the basis that there is a requirement of law that distribution be effected in a compensatory manner as far as the individual is concerned. Paragraph 87 on the same page proceeds on the same basis. They say that the fundamental issue arises here because what's being sought is an aggregate award of damages, and you therefore need to circle back and establish individual loss. And then paragraph 88 is very important in terms of determining the basis on which the tribunal proceeded. And if you could turn please to MS 269 and the final three sentences, you see there the governing principle of damages for breach of competition law is restoration of the claimants to the position they would have been in but for the breach. The restoration will often be imprecise and may have to be based on broad estimates, but this application for over 46 million claims to be pursued by collective proceedings would not result in damages being paid to those claimants in accordance with that governing principle at all. And so we say it's extremely clear from that sentence that the tribunal viewed there as being a governing principle which conditions the way in which distribution has to be effected. And that governing principle is that the claimants, individual claimants, have to be restored to the position they would have been in had it not been for the infringement. And we say, of course, that that's wrong, as that's a misdirection, that's wrong as a matter of statutory construction. The tribunal was not treating the compensatory principle as being simply a relevant consideration to which it could have regard when determining whether the distribution proposal was a fair one. You don't see, that's of course what Mastercard has to argue, but we say that's flatly contradicted by the terms of the judgment itself. You don't see, for example, any exploration of any countervailing relevant considerations. So if the tribunal had been treating it as one of many or several potentially relevant considerations, there would have been a discussion as to whether the disadvantage of having something that doesn't look compensatory to the individual was nonetheless outweighed in the circumstances of this case by considerations of proportionality. And indeed, we say it's only really if the tribunal had it's only really if there were a knockout blow in terms of a legal objection that the tribunal could properly have considered it at this stage anyway, because how could the tribunal possibly lawfully weigh up competing relevant considerations at this early stage when it doesn't even know what the size of the award is going to be? Now, finally, on this point, Mr. Hoskins sought to rely, the court will recall, on paragraph 19 of the tribunal's ruling on permission to appeal. And I'd like to go back to that, please. It's at MS 233. And we say that this does not, quite apart from the fact that the meaning of the tribunal's judgment is to be discerned from the judgment itself rather than from any ex post facto explanation. We say that even on its own terms, this paragraph doesn't support Mr. Hoskins' argument because, in fact, on the contrary, it rather reinforces ours. Look at the first sentence. As regards the second ground, distribution, the tribunal held that the introduction of a collective proceedings regime has not changed the fundamental nature of damages for breach of competition law as being compensatory. So again, back to the governing principle. This is the governing principle. Now, the point, and the last sentence as well, the last sentence is interesting because it records Mr. Harris' concession about the concession being, as Mr. Hoskins accepted, a concession relating to timing. So is it legally permissible for the tribunal to even consider distribution at this stage? But the concession was a point that was put to Mr. Harris. So what the tribunal said was, can the tribunal lawfully consider, can the tribunal take this matter into account? If there's no methodology which can produce a fair distribution of an aggregate award of damages and therefore proper compensation, is this a matter that the tribunal can take into account? Now, that was the question posed to Mr. Harris, and Mr. Harris said yes. But one can see in the question posed a conflation by the tribunal, which we say is an error, a conflation of proper compensation and a fair distribution. And we say that that's the error. Now, the bit of this paragraph that Mr. Hoskins relied on was the sentence in the middle where the tribunal says, contrary to what's stated in the application, the tribunal did not find that it was necessary for the applicant to assess the loss suffered by individual members of the class. And I think the best way of explaining that sentence and putting it in the context of the other parts of this paragraph are to say that the tribunal, it's true, the tribunal did not say that you needed to have a very granular and precise estimate of each individual's loss. But the misdirection was that the tribunal did say you needed at least broadly to compensate each individual. And that, in my submission, is the proper interpretation of that paragraph. So, my lords, on Mastercard's first argument, we say that it's plain that the tribunal did proceed on the basis that there's a requirement that distribution be compensatory, and that was an error of law for the reasons that we give, and as indeed on its primary case, Mastercard would accept. So I'm going to turn to the Mastercard's alternative argument, and then finally deal with the prematurity point. There is another point that Mr. Hoskins has made in his written case, which he didn't press orally, which was that even if the tribunal did misdirect itself, there's no error because it would have inevitably have reached the same result. And he didn't press that, we say rightly orally. We say there's absolutely no evidence on which this court could safely conclude that the tribunal, had it directed itself properly, would have reached the same conclusion, particularly in light. Lord Sales.
Mr. Hoskins did say to us that there were two separate and sufficient reasons for the tribunal's decision, so that even if he loses on the distribution point but wins on the first point, that would be a basis for upholding the tribunal's decision. And that does seem to be reflected in the tribunal's own judgment, where on the first point they reach a conclusion saying for these reasons not suitable, and then they go into distribution and again say therefore not suitable. So I'm not quite sure what point you've just been making. Are you saying that Mr. Hoskins has to win on both points to uphold the tribunal's decision?
My Lord, I'm sorry that I wasn't clear. I wasn't quite addressing that point. I was addressing, I wasn't addressing the point about ground 1 and ground 2. I was addressing a point that Mr. Hoskins has made in writing, which only relates to ground 2. And the point he makes in writing is that if we're right that the tribunal proceeded on the basis that distribution has to be compensatory at some level, and if we're right that that's an error of law, so there was a misdirection, if we establish that, he's argued in writing that that doesn't matter because this court can safely conclude that even if the tribunal had directed properly, it would have reached the same result. And
distribution
so
point.
On this point, on ground 2. And
Right,
so we say, my Lord, I'm grateful. So I'm going to turn to Mastercard's alternative argument. So its alternative argument is that the statute, that if the tribunal did direct itself in the way that we say it did, that this was not unlawful because it's compatible, it's consistent with the statute. And perhaps we can pick it up from Mastercard's written case at paragraph 118, which is at MS 135. So you see at paragraph 118 that you see the argument put there, finally, even if the tribunal did proceed on the basis there was a legal requirement, such a requirement would be consistent with the legislation, essentially. So it's that point that I'm seeking to address. Now, we say, in a sense, I've made most of my submissions on that. We say it's wrong because it would undermine, first of all, we say that there's no sign of any such requirement in the legislation itself, and I've taken you through that. Secondly, it's inconsistent with section 47C2 and would undermine it if it were correct, for the reasons that the Court of Appeals said. And finally, and this is picking up on a point that was put to Mr. Hoskins yesterday by Lord Leggett, once Mr. Hoskins has accepted that distribution doesn't require that an individual be precisely compensated for their loss, then in a sense the point is hopeless. And one can see this from paragraph 118C of Mastercard's written case at the bottom of that page. So a requirement that a proposed distribution mechanism must bear some relation to compensation, however tenuous, is consistent with the tortious nature of the combined claims and not inconsistent with section 47C2. But pausing there, it's extremely difficult to see how that can be formulated or how it would be applied. So it seems to me that either you've got to say that the legislation requires that distribution individually compensate each member of the class, or you say it doesn't and the legislation says that it just has to be fair, which is our position. But what's meant by tenuous link to compensation? There's nothing in the statute that supports that. To see how it could possibly be applied in practice. So, my lords, that's what we say about Mastercard's alternative argument. And I'm going to now turn to the question of prematurity, which was the other basis, which the Court of Appeal, the other respect in which the Court of Appeal said that the tribunal fell into error, and we agree with the Court of Appeal. Now, Mastercard's argument on this point, as I understood it from Mr. Hoskins' submissions yesterday, boils down to being that there is no legal prohibition, no bar in Rule 79.2 to the tribunal considering distribution at the certification stage. And we say that that's true as far as it goes, but it does not answer the question whether the tribunal made an error of law in the present case in refusing certification by reference to the proposed method of distribution. and we say that the Court of Appeal was right to find that it did, the court already has my points on there being no requirement in the rules for a distribution plan to be provided at the certification stage, and generally for this not being one of the mandatory requirements that the tribunal has to take into account. And also, you'll have my points on the legislative scheme providing to the contrary, that this is a matter that's to be dealt with at the end of the process once the size of the award is known. The only substantive requirement which we find in the guide is that the damages be distributed in a way which is fair to class members. And fair means fair in all the circumstances of the case as they pertain at the time that the damages award is made. For all the reasons that I gave in answer to Lord Legate's question to me a little bit earlier, a large award may justify a more complex distribution model. A smaller award may not, and it will turn also on the difficulty of formulating and applying a distribution model which is compensatory. It may be very difficult to formulate one and very expensive to do. And the court also has my point about the role of class members at that later stage in the process. So the rules provide a means for members of the class to put forward their own proposals for distribution and to comment on the distribution proposal made by the class representative. And it would be perfectly open to the tribunal in principle to adopt one of the proposals made by a class member and to reject the proposal made by the class representative. So it follows in our submission that even though there is no statutory bar to the tribunal considering distribution at the certification stage, it will rarely, if ever, be lawful for it to refuse certification on this basis. First, because the tribunal won't have the material necessary to determine what distribution method or formula is fair in all the relevant circumstances. And indeed, the class representative won't have had the opportunity to formulate a definitive proposal in light of all the relevant circumstances, including the size of the award. And second, because the tribunal is not in a position at that stage to hear from class members. So take this case, suppose that there is a trial in which the tribunal makes an aggregate award of damages, but the award is small, then in those circumstances, such that no member of the class would receive a significant sum, regardless of how much money they'd spent. So even the most profligate member of the class who spent an awful lot over the 16-year period won't get very much in the grand scheme of things because the award itself is small. Because, for example, we haven't managed to demonstrate very much pass on, or for any other reason that at trial we may fail on particular points. Then in those circumstances, spending money on a complex distribution scheme which strives to be compensatory to each individual is liable to be disproportionate and therefore unfair. And that's something that the tribunal was simply not in a position to consider at the certification stage. In this case, you've seen from the judgment, the tribunal did not make any assessment of that kind at all. And so it follows that even if the tribunal had directed itself properly, which we say it didn't for all the reasons I've given, it nevertheless acted unlawfully in refusing certification based on distribution at this stage in circumstances where relevant factors such as the size of the award may well have emerged at trial which needed to be taken into account, and in circumstances in which members of the class may have had something to say about the fairness or otherwise of the proposal. So, my lords, those are my submissions on ground 2, unless your lordships have any questions for me.
Thank you very much indeed.
I'm very grateful.
Thank you. Now, Mr. Hoskins.
Yes, my lord. Let me begin with issue 1. Let me begin with the heavy reliance on Canadian law. Canadian law is different. Lord Leggett has made the point on a number of occasions that the Canadian law on certification is not the same as our domestic law. And he's absolutely right about that. In particular, the question whether claims are suitable for an aggregate award of damages is not one of the certification criteria under Canadian law. And I'll show you that by showing you Microsoft MS 1326.
Well, just before you take us to that, Mr. Hodges says that the legislative objective is the same in this country as in Canada. Do you accept that?
The broad objective is the same, but that doesn't really, my submission is that doesn't really take us very far, because what one then has to look at is how has the Canadian legislature sought to give effect to the objective, and how has the United Kingdom legislature sought to give effect to the objective. And as I'm about to show you, they've adopted a different approach.
Right. Well, sorry, you were taking us to 1326.
Yes, so what you have at paragraph 62 at the bottom of the left-hand column, the English column, is you actually have the British Columbia Class Proceedings Act set out. So this is the Canadian legislation. And in Canada, a proceeding must be certified, so that's different from the UK, where if the criteria are met, there's a discretion for the tribunal to certify. And then the requirements are set out: disclose a cause of action, identifiable class, common issues, preferable procedure, and then a representative plaintiff. Sorry. So you don't see the specific suitability requirement that we see in our legislation. Then paragraph 127 at MS 1351. You see the heading aggregate assessment of damages, and then you'll see there is a separate provision on aggregate damages in the British Columbia legislation, and that's at 29 of the relevant CPA of the Canadian Act. So those are the two legislative provisions: certification, award of aggregate damages, and then Justice Rothstein expressly considers the relationship between them. If I pick it up at paragraph 128 on MS 1352, you see in the middle of 128, however, while the aggregate damages common issues certified by Myers J deal only with the assessment of damages and not proof of loss, and Myers J was the first instance judge in Process and Microsoft, there is some confusion in his reasons about whether the aggregate damages provisions of the CPA may be relied on to establish proof of loss, where proof of loss is an essential element of proving liability. Paragraph 129, in this case, Myers J concluded that the aggregate damages provisions can be used to establish what I interpret to be the proof of loss element of proving liability. And this is the point Lord Leggett put to Mr. Harris yesterday. This is dealing with establishment of liability, not certification. Paragraph 130, in finding that the aggregate damages provisions of the CPA can be used to establish proof of loss to the class as a whole, Myers J followed a line of jurisprudence of the British Columbia Court of Appeal, and then there's a reference to that. Paragraph 131, with respect, I do not agree with this reasoning. That's Justice Rothstein. Then 132, I agree with Feldman J.A.'s holding in Chadha that aggregate damages provisions are applicable only once liability has been established and provide a method to assess the quantum of damages on a global basis, but not the fact of damage. Aggregate damages are not a certification requirement in Canadian law. The second point on the attempt to rely heavily on Canadian law is commonality is not the same as suitability. Reference to the Canadian court's case law on the issue of commonality is not appropriate when dealing with our distinct legislative requirements of suitability. Under our legislation, commonality and suitability are two distinct conditions and each must be fulfilled. One cannot simply say, I've established commonality, therefore I've established suitability under the United Kingdom legislation. So again, a different position from Canadian law. third point on Canadian.
Mr. Hosking,
Of course, sorry. I'm sorry.
If I've correctly taken on board your lightning quick run through the Canadian statutory provisions,
Yes, sorry.
They where we use suitability, they seem to use the concept of preferable procedure.
I'm only hesitating because I don't know if it's exactly the same.
If you look at
criteria.
If you look at electronic page 1327, and you see the statute set out. So you have A, cause of action, B, identification, 3, commonality, 4, a class proceeding would be preferable procedure.
Yes.
And that seems to be their I'm not going to say how close or separate they are immediately. Preferability is separate from commonality under their regime, as far as I can see.
Yes, clearly on the face of their legislation.
And preferable, one asks, well, preferable to what? And that must mean preferable to leaving individual claimants to bringing their own claims.
That must be one of the considerations. And again, I don't know if that's the only consideration under the Canadian law.
The word preferable carries with it, doesn't it? Preferable over something else.
Yes.
Now, in our case, we use the word suitable. But my question for you is that really any different? In a case where there is a cause of action and there are common issues, and the alternative is leaving everybody to pursue their own claims, is suitability a sort of freestanding requirement, or is it really just another way of saying preferable to leaving everybody to pursue their own claims?
I think it is broader than preferable to everyone to pursue their own claims, because, for example, there's the question of whether, even if, for example, it is better than leaving everyone to pursue their own claims for it to become collectively, is it suitable for an award of aggregate damages? And I think you pointed out to Mr. Harris that in Rule 79.2a, you've got a sort of echo of the Canadian preferability point, but you then also in our legislation, unlike the Canadian legislation, have the specific reference to suitability of aggregate damages award.
Well, I think A is just the commonality point coming back in, isn't it? But never mind that for the moment. Yes, I can, and they deal with aggregate damages in a quite separate section. But I'm really looking at the concept that the opening, the threshold concept that this claim must be suitable for common proceedings, for class proceedings, and asking whether that is really an abstract or whether it's another way of saying, is this a better way of doing it than leaving everybody to pursue their own claims?
And my submission is it is broader than that. For example, because of the specific requirement that you must consider whether the claims are suitable for an aggregate award of damages. That notion of suitable for an aggregate award of damages goes beyond simply, is it better to let this come, everyone to bring it at the same time or individually? That is a different concept, or it's a different in nature concept.
But you don't say that requirement is a threshold requirement, but just one of a number of factors, do you?
Absolutely. In Rule 79.2, tribunal should take account of all matters it thinks fit.
And none of those are of themselves hurdles that must be jumped over.
Necessarily, but they may be, because one of these criteria may be so deficient in an application that that's enough.
Yeah, understood. Thank you very much.
Thank you. Next point I'd like to address on issue 1 is the sort of vexed question, the core question of what does some evidence mean? Now, the tribunal, the Court of Appeal, and both the parties in this appeal all agree that it is consistent with our domestic legislation for the tribunal to have asked, as a matter of certification, not merits, whether there was some evidence of the availability of the data to which the applicant's proposed methodology was to be applied. That is accepted to be a relevant question at the certification stage. Now, Mr. Harris gave his wealthy individual point and said, well, if a wealthy individual brought this, they wouldn't be asked to show that they had data available at the early stage. But of course, the obvious answer to that is because there's no certification requirement for an individual claim for a claim by an individual in the High Court or the tribunal. That's the difference here. There is a screening process for collective claims. Mr. Harris's submission is that all an applicant has to show is that there is some, as opposed to no evidence, that there has been some degree of pass on to consumers, but not as to what the actual level of that pass on was. But the problem with that is that formulation doesn't actually tell you whether the applicant's proposed methodology for calculating aggregate damages is practicable or not. Because as I showed you in my opening submissions, the applicant's experts explained that their methodology would require evidence about the level of pass on in each sector of the UK economy over the duration of the infringement period. So Mr. Harris's some evidence of pass on to indirect consumers, but no more, doesn't even begin to engage with what is accepted by Mr. Harris to be a relevant legal inquiry at the certification stage of whether there is some data available for the expert, for the methodology proposed by his expert. It simply doesn't engage with what the actual issue is, which is common ground between the parties. Mr. Harris also submitted that if there was some evidence of pass on to consumers, then the tribunal should grant certification for the whole claim. Then wait, see what disclosure is produced, and then, if necessary, revoke or amend the scope of the CPO. And in our submission, such a suck it and see approach is unacceptable. First of all, as I submitted yesterday, the fact that the tribunal has a power to vary or revoke a collective proceedings order at any time cannot excuse the tribunal from the express obligation imposed on it by sections 47B sub 5 of the Act to decide at the certification stage if it is satisfied that the statutory certification preconditions are satisfied or not. You don't get past go unless at the certification stage you have satisfied the tribunal of the statutory criteria. Second point is that as a matter of law, it cannot be correct that if the statutory conditions are met in relation to part of the claim, but not in relation to all of it, that the tribunal should nonetheless give permission in respect of the whole claim. And I take, by way of example, judicial review. If a claimant seeks permission to bring proceedings in respect of 4 grounds, and the court considers that 2 of those grounds pass the statutory test, but the other 2 do not, then permission is given for the 2 that do satisfy the relevant criteria, not the whole claim. The third point, Mr. Harris submitted that it would have been too difficult and costly for the applicant in this case to have sought to identify whether data necessary to carry out his proposed methodology would be available. But of course, that difficulty that he's seeking to rely upon is precisely because of the breadth of the claim that the applicant has chosen to bring. The other applications for CPOs pending before the tribunal, which you've heard reference to, are much narrower. So for example, one of them concerns the effect on car prices of the cost of transportation by ship. Another example is the effect on ticket prices charged by certain rail companies. Now, in the context of such focus claims, mass consumer claims, but focus claims, the task of seeking to identify available data is clearly far less onerous than in this case. But what has happened here is the applicant, his legal team and his funder have decided, have chosen the scope of the application that they are seeking permission for. They could have chosen to seek permission for a narrower claim, limited to petrol or supermarkets, but they didn't do that. And having decided to bring a juggernaut of a claim, the applicant then cannot argue that it should be given permission, even though it can't meet the certification requirements, precisely because of the scope of the claim it has chosen to bring. That would be the tail wagging the dog. You decide what claim you want to bring, and you have to meet the criteria. You can't say, because I've sought to bring such a large claim, I don't have to meet the criteria. Let me turn to the question of disclosure. Mr. Harris sought to take you into the detail of the evidence that was before the tribunal. For example, he suggested that the many retailer actions brought against Mastercard would be likely to produce the data necessary to carry out the applicant's proposed methodology. Now, my first point is this one. It's not open to a person in Mr. Merrick's position in an appeal confined to points of law to seek to open up the tribunal's assessment of the evidence before it. I started my opening submissions with just simply summarizing, as you're all well aware and familiar with, what an error of law means. And it doesn't mean asking this court to grub through the details of the evidence and form its own conclusion, as opposed to that the tribunal reached. And in this case, the tribunal considered the evidence before it. And of course, this court hasn't been taken to all the evidence that the tribunal saw. And the tribunal came to the conclusions on retailer actions, for example, at paragraph 70 to 73 of its judgment. And that assessment in our submission is not open to challenge in an appeal on a point of law. But secondly, even if one were to descend into such factual issues, the retailer actions largely do not cover the same period as the applicant's proposed collective proceedings. And I'd like you to look at the evidence that the applicant's experts gave in relation to this, the oral evidence. It's in the transcript of day 2 before the CAT. It's MS 747. Sorry, I'm just being slow with my paper. And I'd like to pick it up at line 23. And this is me asking questions, obviously. Do you know what period the disclosure in Sainsbury's relates to? Well, that period only overlaps about 18 months of our infringement period. The disclosure in the Sainsbury's covers the period from December 2006 onwards, does it not? Yes. Remember, this claim covers 1992 to 2008. And then a reference to the Arcadia or Morrison's case at line 31. The disclosure in the Morrison's case covered the period from April 2006 to the present date. Right. So again, a limited overlap. Yes, my underlying thinking about this is that data that may be useful will be revealed in these cases. I recognize that the overlap period is limited. You go back to Appendix 3. You say, we've been instructed that claims already issued against Mastercard, for example, then you list some of the claims that have been brought. Just to check, when you say we have been instructed that, have you seen copies of the pleadings in these cases? No. Do you know what periods are covered by those claims? Not specifically, apart from the Sainsbury's. Okay, have you got a pen with you? Yes, you might want to jot this down. And then you'll see if I tell you that in the best case scenario, in all the other retailer actions, there would only be disclosure in relation to Pass On in the United Kingdom prior to 2006, in relation to Dixons in the electronic sector, in relation to Car Hire, Auto Europe, Hertz and Europe Car, in relation to transport, TfL and British Airways, and in relation to clothing, Inditex and ASOS. So imagine you've got disclosure from all those retailers in relation to prior to 2006. I think it is stating the obvious, and I'm sorry if most of my questions are obvious, that would not be anywhere near sufficient for you to carry out the analysis you've been discussing with the tribunal. Answer, not using that data source. He agrees with me. So what you would have to do is to obtain sufficient evidence by other means in respect of the period from 1992 to 2008, correct? Correct. So he's accepting that he would have to get data from sources other than retailer actions. You would need evidence in relation to each of the different markets that exist within the sectors we've been looking at, would you not? Well, we would be looking principally at the main markets and whether, if you take British Airways, the airline sector is pretty much well researched, etc. We don't need to go to the British Airways. And then over the page, as I think we've already established, we would have to look at each market separately to see what the appropriate approach was. Yes, some may be easier than others. Some may be easier. As a first cut, we'd be looking at markets, and then we would decide which ones to explore in depth. You do not yet know how many markets you would need to look at. You have not done that exercise. Answer, not at this stage, no. And then going down to line 15, you've accepted, I think, that because pass-on rates within a market may change over time, you need evidence to cover the period as a whole. A snapshot is not going to be enough for most of these. Ideally, yes. Again, apologies for asking the obvious. You have not yet made any assessment of the actual evidence that you might need for the markets you want to look at. Just the evidence that you would have to go and get, or try and go and get, the sources, etc. You've not done that yet. Answer, not at this stage, no. So when Mr. Harris says, well, we can't be expected to do all this, and we have actually got a lot of it, you'll see that quite obviously the experts, either of their own volition or because they were not instructed to do it, simply didn't carry out the exercise of looking to see whether some data was available to support their methodology. It just wasn't done. Now, Mr. Harris suggested that they could look to Mastercard for the relevant disclosure, but of course, if the relevant disclosure from retailers doesn't cover the periods addressed, as I've shown you, then it doesn't help to look to Mastercard rather than the retailers for it. It's the same disclosure and it still doesn't cover the relevant period. In relation to the RBB report, it's not the case that the tribunal engaged in an exercise of looking at its quality. It looked at the availability of data. Can I ask you to go to the tribunal judgment, paragraph 51 at MS 2560. Sorry, MS 256 at 257. MS 256. So you'll see paragraph 51, we refer to the report by RBB Economics. And then on page 257, above the first bullet, discussing the availability of evidence for particular sectors, the report found the following. This is looking at availability, not at quality. 52, in summary, Mr. Hoskins submitted that the experts had not made any proper examination of what data material was available to produce appropriate and meaningful figures. Then at MS 264, Tribunal Judgment Paragraph 75 you've seen before, the experts emphasised there was a lot of published data and studies. However, that is precisely the material surveyed in the RBB report, which found it incomplete. I.e., the data isn't there. It's not a question of its quality. Certainly insofar as there is some data, it's difficult to interpret. But the principal point that's being made is there simply isn't the data before you even get to questions of its quality. Mr. Harris referred you to the reference to the VAT material, which was one paragraph of the report. That's MS 546 and 547. And you have this point, because I've made it already. It's at page 547. This is not empirical evidence of what actually happened. It's people speculating about what might happen, and that's it. And there is certainly no suggestion by the applicant's experts that that would be sufficient for him to carry out their methodology. In relation to the supplemental report, you have my point. Legality of the tribunal judgment must be assessed on the evidence that was produced before the tribunal. Mr. Merricks was entirely on notice that this issue of data availability was going to be central to the certification hearing. Can I ask you to look at MS 358? And this is Mastercard's response to the application. And you'll see at paragraph 55, so this is Mastercard's pleading. The crucial question is therefore whether an aggregate assessment of the loss suffered by the class as a whole is likely to be both practicable and sufficiently accurate to comply with the compensatory principle of damages. And we then develop those points, including the issue of practicability. And you'll see that we refer specifically to the paragraph 6.2.4 of the expert report at paragraph 60 of our pleading. And we make various comments on it, and the punchline over the page at MS 361, paragraph 61D, as accepted in paragraph 6.2.4 of the expert report, the approach suggested will depend on the availability of evidence and whether that evidence relates to the same period as the full infringement period. There is no realistic prospect of obtaining sufficient evidence from a sufficient number of different merchants for the full infringement period, which runs from 1992 until 2008. That was one of our principal arguments. It was flagged up before the CPO hearing. If the applicant had wished to put the expert's nose to the grindstone, he had every opportunity to do so, but for whatever reason, chose not to. The applicant chose to stand or fall on the expert report that you have seen, and he fell. And it's not appropriate now, having brought a claim for £14 billion, having brought it on that basis, to try through the back door to recover the position by putting in a supplemental report now. All the evidence in the supplementary report was available at the relevant time. The Court of Appeal make that point in its judgment. This is not new material that has come to light after the event. It was material that was available at the time of the CPO application. I come back to a point I made earlier. You must bear in mind, this is essentially a commercial project by the solicitors and the funder. And all that has happened in this case is they failed to bring a proper case before the tribunal. And that's the reason why it failed. That's what I wanted to say in relation to issue 1. Let me deal briefly with the issue 2 points. I've made a lot of my submissions. I'm not going to repeat them, and indeed I wouldn't have time to do so in the 10 minutes available. But let me try and take each of the headings and make some points in relation to them. First of all, the interpretation of the tribunal's judgment. Did the tribunal assume, as a matter of law, that in every case, distribution must have or must take place with reference to the compensatory principle? Now, you've been taken to the various paragraphs of the judgment, and you will form your view of those paragraphs in the judgment. But you have 2 judgments from the tribunal on this issue, and it is absolutely open to this court to look at both of them. In fact, it should look at both of them. Where a court gives 2 judgments on the same issue, you look at both of them. You don't pretend the second one doesn't exist. And the permission to appeal judgment is absolutely clear on this point. MS 233. And you were taken to this by Ms. Dimitriou, but of course the crucial sentence here is the one that begins about 6 or 7 lines down. As noted in the observations from Mastercard, it is a mischaracterization of the judgment to contend that the tribunal found that there were substantive legal requirements which the proposed distribution model must meet. And that makes absolutely plain that the tribunal, in its original judgment, had not proceeded on the basis that there was a substantive legal requirement that a proposed distribution model must reflect the compensatory principle. It's absolutely clear, and that's the point the tribunal indeed was responding to in the application for permission. So if it's the case that the tribunal was not proceeding on that basis, was it nonetheless entitled to take account of the compensatory principle as a relevant consideration? Well, Ms. Dimitriou, on behalf of the applicant, has accepted that it was open to do so. It was open to the tribunal to have regard to compensation in particular cases. Now, in this case, the claimant's experts, as I've shown you, gave evidence that the proposal bore no relation at all to compensation. And the claimant's experts also gave evidence that they had not investigated other possible methods that might be more compensatory. And faced with that evidence, it was entirely open to the tribunal to reach the conclusion that it did not believe that the suitability requirement was met. Now, Mr. Mitra made the point that there was no reference to competing considerations. So what you don't find is, well, on one hand, there are experts say no relevance to compensation, and here are a number of other criteria that we weigh up. But as we said in relation to the first issue in my exchange with Lord Briggs, it is perfectly possible for the tribunal to take the view that one consideration is a knockout blow. And that's what it did here. And that assessment by the tribunal, again, cannot be interfered with as an error of law. It's an exercise of judgment by the tribunal on the evidence before it, and it was entitled to come to that conclusion. On the prematurity point, to finish up, Mr. Mitra, I'm sorry, Lord Leggett.
Can I just ask you, if it isn't a legal requirement to consider whether the proposed method of distribution has some relationship with compensation, how do you decide whether it should or shouldn't in the particular case? Do you just think, well, this looks to me like it ought to here, or do you have to go into some kind of evaluation of what is fair on the facts of this case? And if the latter, where do we see it?
Well, the basis upon which the tribunal has taken its decision is that, in its view, in the circumstances of this case, without identifying particular ones, because the distribution method bore no relationship at all, it did not believe it was suitable. And obviously, it's not. I cannot conjure out the air what was in the mind of the tribunal. So I simply note the point that it was open to the tribunal to consider this as a relevant consideration. It had evidence before it about the nature of the distribution model. It reached a judgment on it. And my submission is there is no error of law in that. But I cannot speculate on what may have lain behind in the thinking in relation to that. I don't seek to do so, my lord. It wouldn't be appropriate for me to do so. Prematurity, which is the final point. Mr. Mitra raised the point that there is no specific requirement in the rules for distribution to be addressed by an applicant. But as I showed you, the applicant in this case did raise the point in its own claim form. And where the applicant has raised a point, it is perfectly, or the tribunal is perfectly entitled to consider it. Just because it's not specified in the rules doesn't mean that a particular matter that is raised by a claimant or indeed by the proposed defendant cannot be considered. That's not a bar to its consideration. Second point Mr. Mitra said is, well, what about the role of class members? She showed you the rule which said that after an award of aggregate damages, class members can apply to make submissions. But actually what she didn't show you is that class members can also participate at a CPO hearing. And therefore it is open to class members if they wish to comment on a proposed distribution methodology. Can you look at MS 1182? It's Rule 79, sub 5. Any member of the proposed class may apply to make submissions, either in writing or orally, at the hearing of the application for a collective proceedings order. So the suggestion that there's some sort of procedural block that means that the distribution can't be considered at the CPO stage is not correct, because the rules do provide for class members to make submissions on distribution at the CPO stage if they wish to do so. And the final point was to say, well, it's premature in this case, and it was an error of law in this case for the tribunal to take the decision it did, because you won't have sufficient evidence at the CPO stage to form a view of a distribution methodology that's proposed. But of course, the question of whether the tribunal thinks it has sufficient evidence to reach a view will depend on the facts of each particular case. It can't be a hard-edged question of law whether there is sufficient evidence for the tribunal to reach its view or not. And the particular point that Ms. Dimitriou put to you was that it may well be that where the distribution to individual class members is likely to be small, then it may not be appropriate to actually invest more money in coming up with a more finessed distribution methodology. But with respect, in the context of a claim for £14 billion, to say that the applicant couldn't have given more thought to possible distribution methodologies, including ones that bore more relationship than none to the compensatory principle, is a pretty extraordinary submission. If you've got a pot of gold at the end of the rainbow of £14 billion, you absolutely should be doing the work to convince the tribunal that you've met the criteria. Well, those are my submissions, unless there are any further questions.
Thank you very much indeed. We're very grateful to Council for the very helpful submissions, and no doubt to those who assisted Council in making their presentation. We will take time to consider our judgment, and it will be delivered not in the normal way, or it'll be delivered in the new normal way in due course. Thank you very much indeed. Course now adjourned. Thank you.